The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court, from recess, now sitting.
Thank you. Please be seated. Now call the third case on this morning's docket. That is case number 102055, State of Kansas appellee v. Michael Ray Hensley, appellant.
Good morning, Your Honor. Happy Kansas Day. My name is Randall Hodgkinson. I'm here today on behalf of Michael Hensley. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, my intent is to kind of take these issues out of order because I really have mostly things I want to talk about on the third issue more than the first two issues, but I'm usually wrong and the court usually corrects me. But on the third issue, in this case, which has to do with multiplicity issues between a conviction for possession of marijuana and possession of marijuana without a tax stamp. And to be honest with you, Your Honor, I think I could copy this brief and use it as a law school exam in some ways because it's sort of this weird situation and applying the court's analysis after Schoonover, we kind of have to figure this out.
Is this a purely constitutional issue, or is it a partially a statutory situation, or does it matter? Because we have the statute that says you could convict of a crime where it's lesser but not both. And if so, if it is statutory, do we get into all of the tests and factors and whatever that we utilize for multiplicity in the constitutional context? Am I making any sense to you?
I think so.
Can this be simpler than looking at a constitutional multiplicity issue?
It is simpler than that. I mean, under the statute. Now, I would argue, and I think this court has even said, the statute is, and the rights that are spelled out under 213107 flow from the Double Jeopardy Clause. And they're sort of Kansas codification of what we might have. And in fact, I think after Schoonover, it's really not that different. So at the end of the day, I'm not sure that it makes that much of a difference. But certainly there is the statutory argument in this case. And I think the Schoonover court said we're going to go with this strict elements test. Now, there might be some other tests under 3107 occasionally, but for what we're dealing with today, we're dealing with a strict elements test. And I think that is the same.
But are we, because the statute says you could convict of the crime or the lesser, but not both, and then the statute defines lesser as an offense where all of the elements of the lesser or some of the elements of the greater, or a lesser degree of the same crime. And certainly an argument could be made that possession of marijuana is a lesser degree of possession of marijuana with intent to sell or intent to distribute, or without a tax stamp. You see what I'm saying? There's two ways to get there, and the second way doesn't involve an elements comparison.
Yes, Your Honor. I think you could make that. I'd have to confess I did not make that argument that there are lesser degrees of the same crime, of a drug crime, for example. And I mean, I'll just be candid with you. I think that's because, and on some level, the court has talked about that no tax stamp, or at least the Court of Appeals has talked about no tax stamp being a different object. And that's sort of the state's response here, is these crimes have different objects. One of them is criminalizing possession of drugs, and one of them is a tax crime, which is fine, maybe under before Schoonover analysis, when we used to do like single act of violence test and things like that. But we focused in this case, after Schoonover, more on the strict elements, because I think under the strict elements, in this rather unique situation where we have possession of marijuana being a lesser of the tax crime, but having all of those elements, that we do meet that statutory test. That under the statute, possession of marijuana without a tax stamp requires that a person possess marijuana. The Court of Appeals got a little tricked up on this and said, oh, no. The no tax stamp statute only applies to dealers. but then fails to go on to note that the definition of dealer in a statute is that a person possesses the required drug. And so, in fact, for no tax stamp, for possession of marijuana without no tax stamp, the state, under the statutory elements, has to show that a person possesses a certain amount of marijuana without the tax stamp. The elements of possession of marijuana are that a person possesses marijuana. All of those elements are clearly included in the statutory definition of no tax stamp. We don't usually get to this issue because possession of all the other kinds of controlled substances isn't a lesser of the tax crime. Possession of cocaine or possession of methamphetamine isn't a lesser. It's a greater crime. It's still included, I think, under the definition, but it's not a lesser included. And so we don't get to this. And, for example, as this crime was charged, possession with intent to sell and no tax stamp, I don't think I could make this argument there because in that case, no tax stamp is the lesser, and it has elements that aren't in possession with intent to sell, so I wouldn't be able to make that argument. But because of the unique circumstances here where the jury was instructed, where Mr. Hensley was charged with possession with intent to sell but was only convicted of the lesser possession of marijuana, we end up applying 21-3107 as it relates to what he was convicted of. And that's multiplicitous. That's prohibited by statute. And I think it is prohibited by the double jeopardy clause.
Isn't it possible, though, even if we agree with you that it is duplicative or that they're both essentially one is a lesser of the other, of the greater offense, that the legislature intended nevertheless for there to be a cumulative punishment for this particular offense?
I don't know how you do that and get around 21-3107, Your Honor. I mean, I can get to a point where I could see the court saying, as it has sort of in the past, that the gravamen of these offenses is different. But the test set out by the legislature in 3107 is, are all the elements of the lesser in the greater?
But the legislature could also indicate an intent to override that and to cumulatively punish, and we've recognized that, to cumulatively punish nevertheless. And I'm asking, do you think there's any intent expressed here to that effect?
I don't see any exception to 3107 for this or any other situation where the legislature has evidenced that intent, or where it says in the tax crime statute, this is to be in addition to anything in the Controlled Substances Act.
Like they did in felony murder.
Right.
It has to be that explicit, you believe?
It would have to be at least to overcome the clear language of 3107.
When you were answering Justice Johnson's earlier question about whether we were looking at constitutional or statutory, I was thinking that this is where you would go, that what we are talking about here today is not the constitutional test where we would then go to the next step to see if there was an override of legislative intent through that wasn't expressed, because we have an express statute. So we're looking at that express statute. Is that kind of what you're saying? I
think it's both. I mean, I think this is the codification. And I think after Schoonover, I think you said we're going to use essentially, and the statute does set out the constitutional test. And so unless there was some sort of other really explicit situation. But I'm thinking even in that explicit situation, I don't know if the legislature could get around the double jeopardy clause in this situation where all of the elements are included in the elements of the greater. I haven't thought that out tremendously.
They've done that in felony murder, haven't they?
But all the elements aren't the same.
Except that I think that the U.S. Supreme Court has recognized that has said that the elements test is just a measure of legislative intent and that the ultimate goal is legislative intent. The ultimate test is what did the legislature intend.
But under the same offense, when the double jeopardy clause talks about not being convicted or punished for the same offense test, the part of the Constitution, the double jeopardy clause, is the same elements test.
But I don't think they've said that's the end all. They've said that that helps you analyze the intent. But I think that under their case law, even with the strict elements test, if there are other indications of legislative intent, you can go in, you can accept that. But I don't think that. But I'm suggesting that under our statutory test, there has to be a pretty explicit exception to the statute to get around that.
Well, I clearly agree with that. On the first point,
Not sure
I'll have
about
to go
the
back
other.
and read Blockberger and really think about it. I haven't done that in the context of this case because I'm certainly holding out. I mean, I'm not giving up on the Constitution in this case, or that this is a constitutional issue under the Double Jeopardy Clause, but I am certainly relying on the codification of what I think the Double Jeopardy Clause is from the Kansas legislature, which certainly this court has relied on.
Well, to add to your, let's assume that we can take it one step past that constitutional issue and the codification of it to a legislative intent that might have expressed a cumulative punishment intent. And what about the fact here that they chose to include this statute, the dealer tax essentially, in the Drug Tax Act in a completely different statutory scheme than the criminal statutes? And I think at least one court has held that that is could be evidence of intent of cumulative punishment. How would you respond to that?
It's evidence that there's a different object, that one of them is, and I think it's fair maybe to say that that's evidence of that there's a different object, but it doesn't negate the elements test as set out in 3107. It doesn't say 3107 doesn't apply to this or anything else that explicit.
It definitely isn't explicit, but it is unusual, wouldn't you agree, that we would have a criminal act punished separately outside the criminal code in a drug tax act? It's not typical. And it might be some indication of intent.
This is an unusual, the facts in this case are unusual. I will have already admitted that. And so, and I can't change that. But at the end of the day, this court looks at legislative intent sometimes, but not when there's a clear direction from the legislature. And the legislature has in 3107 pretty clearly said, here is the test to use for whether something is a lesser included or not. And you cannot convict somebody of a greater and a lesser. And so I don't know what would cause you to move past that clear language to this idea. In a pre-Schoonover world, I think there was a strong argument there to say, look, these are different things as evident. You know, the object of this is different. But in a post-Schoonover world, I think we're looking at the statute. Your Honor, with my last 38 seconds, I would talk just on the first issue, that's all I had to say anyway, is the Court of Appeals has complained in this case about our failure to put on what Ms. Post would have said, because that's our big complaint in the first case, that the district court didn't cause Ms. Post to appear. And certainly even the state in its blue brief has gleaned the idea, the theory here, that Ms. Post has information about Mr. Hensley and may have had motive to do things against Mr. Hensley, and that's what we wanted to talk to Ms. Post about. We did not have an explicit proffer from Ms. Post because we never were able to bring her to court. We don't get to do depositions in criminal cases. And so, of course, our information that we have is somewhat limited. But it's clear through the course of the proceedings here that Ms. Post isn't some random person that has no connection with this case.
I realize the Court of Appeals made their decision on that based on the materiality. Essentially, the there'd been a failure to proffer materiality of her testimony. But I'm wondering if we even need to get that far, because I don't see anything in the record that indicates that, it appears at least from the record, that there was some attempt the day before trial ended to get her there the next morning, and everybody agreed she'd be there the next morning. And then there's nothing in the record the next morning that defense doesn't put her on. There's no comment that she didn't appear. There's nothing. So why would we assume that she didn't appear and that was in violation of the statute, if that makes sense, a failure to?
Oh, sure, it makes sense. And, Your Honor, my response is, how many times do we have to ask? I mean, on the first day we'd say, Judge, the defense attorney would come and said, Judge, I had her subpoenaed to be here at 9 o'clock. She's not here. I subpoenaed her to be here all the time. Would you please help me get her here?
Right.
And the judge said, I don't know. I don't think we're going to get there. And repeatedly through the proceeding on that first day said, Judge, I need help getting her. And in fact, the judge is empowered to send the sheriff out, bring her in, put her in jail if you have to.
But that's my point. I don't disagree with you, but I'm saying ultimately, the way the record reads, everybody thought she was going to be there the next morning. And there would be the opportunity to put her on. And then that doesn't happen, but there's no explanation of why it doesn't. So are we supposed to make assumptions about that? Even if we agree with you that the repeated requests should have been enough, it seems that they did make that effort But then there's nothing in the record to show what happened.
Our position would be that we establish the compulsory process violation by the court's failure on the first day. To the extent that there's a sort of absence or silence in the record after that point, that should be held against the state in this case to show, look, Your Honor, we just wanted to put on record that they were complaining about this yesterday. What's going on this? Do they not want her anymore? There's
we
no
don't even know
showing
if
that
she
they don't want her
appeared,
there
though.
anymore.
I mean, we don't know if she appeared. She may have appeared, and that may be exactly what. So you think that's the state's burden now to show that she appeared and that the defendant didn't want her there? That's the state's burden to show on appeal that all took place?
Your Honor, I guess, as I stand here thinking about it, my point is we've established the compulsory process violation. As far as remedy goes, if the court says we don't feel like it's the right situation to do this, maybe you remand it for findings on whether or not this situation that you've talked about was the case, as opposed to assuming it, because I know the court is loath to assume those kind of things. But where we've established what we think we've established the compulsory process violation, that should be what we need to get further action by this court.
Any further presentation, counsel?
No, Your Honor.
Any further questions of counsel? Thank you.
Thank you.
Good morning. May it please the court. Amy Norton, Assistant Saline County Attorney on behalf of the state in this case. And I am going to start, I think, with the first issue. I don't believe Ms. Post had any idea what she was getting herself into when she decided to speak to investigators about Mr. Hensley. But as the Court of Appeals had found, there does have to be some sort of showing by the defense that there is material and therefore relevant evidence that this person that they seek to compel to come to court would offer before the court has a compulsory duty to act to bring that person to court.
You're not saying that a defendant has to prove the bona fides of their defense or the efficacy of their defense before they can exercise their constitutional right to present a defense, are you?
No, the state's not going that far.
And the defense here was she lies, she's lied before. I think she may have planted or participated in planning of the drugs. She set me up. I mean, what more does the defendant have to do to explain his defense?
Well, with all due respect, that proffer, that explanation that the court has just gone through was not made at trial. There is no record that at any point from the beginning of trial on the first day through the end of the trial on the second day that defense counsel, Ms. McKenna, ever explained to the court why Ms. Post's testimony was needed. In prior proceedings, the motion to suppress, that's the heart of issue number 2, there had been some very vague references that Ms. Post was necessary to the defense, but no real explanation of why. And without something further, and not even to go so explicit as to, we're going to ask these questions, she's going to answer in this way, but just to explain to the court, this is why she's important, this is what we expect her to provide in terms of testimony. Without that further proffer, the court, basically a defendant could come in and say, well, the President of the United States is in Wichita on a whistle-stop tour, and they have he has material testimony to provide, judge, go issue me a bench warrant.
I guess I don't understand. The state can call whatever witness they want. When they proffer the testimony in trial, there's a subject to objection, and we say that defendant is given the right to present a defense and is provided with the same subpoena power as the state, but we're going to make the defendant prove that to the judge that it's good evidence before we let them exercise that right?
I think, Your Honor, there's a difference between allowing somebody access to compulsory process, such as issuing subpoenas, versus allowing them unbridled, unfettered access to compulsory process. As the Court of Appeal found, there's really nothing that says that particular right should be treated any differently than any other type of right.
Well, I can understand that if the person subpoenaed would come in and ask to quash, or the state would move to quash. But I didn't understand that to be the case here. The judge was just playing gatekeeper on which subpoenas the judge wanted to enforce and which ones he didn't. And I guess I don't understand why that's the rule. Why does the judge get to decide which subpoenas to enforce until someone has challenged?
Well, the state did file a motion in limine prior to the beginning of trial, arguing that Ms. Post would have no material or relevant testimony to provide. This was presented to the jury as a search warrant case. The officers, basically a testimony starts with the officers executed a search warrant. The information in that search warrant provided by Ms. Post is therefore basically, as the state's position would be, inadmissible and immaterial to the case. If her sole testimony is going to be what's based on in the search warrant, which is an assumption we have to make because the record is silent as to what exactly her testimony was going to be, then yes, the judge is acting in the same gatekeeper fashion as with any state's witness. If a witness is not going to provide admissible, relevant material testimony, regardless of who tries to call that witness should not be allowed to testify. And the state, on the second day of trial, specifically, before the defense started its case, re-brought up the issue of the motion in limine and Ms. Post's testimony. The state inquired about the proffer, whether or not the defendant was going to make any sort of proffer as to why Ms. Post's testimony was relevant, and the defense did nothing. So I think this court is constricted by the silent record as to what Ms. Post was apparently going to testify about. We can speculate as to what happened, but the State versus Adams, cited by the Court of Appeals, says that just because the statute lays out that a defendant has the right of access to compulsory process does not mean that the district court has stripped of any discretion as to how to impose that. And I think a fair reading of the record here indicates that we have a witness who appears she had shown up to court on the first day and then did not remain, had gone home. And yes, at that point, without making any sort of proffer as to why her testimony was relevant, the defense counsel immediately jumped to a pickup order. I think it's a fair use of discretion for the district court to say, we're not to your case yet. Let's try some less, severe methods before we get there. If those methods don't work, then, bring it back before me and we'll take it up at that point. And it was never brought back up. There
was a statement, and I think it was in response to the state's motion in limine by defense counsel about in response to saying, no, we are going to need Ms. Post's testimony about the relationship between the two of them. And there's a specific statement that she's made false reports in the past. She changes her story. That she may have planted the information. There's a statement. There's nothing more. And the judge says, well, you're going to have to basically, proffer some more specifics on that at some point. And then that's never returned to. But there is that statement with some detail. And it seems that everybody knows what they're talking about because there's been this issue about discovery, about the prior, information she's provided to law enforcement. Well, and again, going back over just what the record says, I know in Mr. Hensley's brief there's some reference to this, but there's really, other than statements at a prior proceeding by counsel or allegations basically that there might have been these prior false reports, there is no evidence at any point in the proceedings that Ms. Post ever made false reports. In fact, it's quite the opposite. At the motion to suppress hearing regarding her statements included in the affidavit for the search warrant, Investigator Swanson specifically said, I went and checked to see if she had any convictions for any crimes of dishonesty. I did not find any. I did not find any record that she had ever made anything that could be remotely considered a false report before against anybody, much less Mr. Hensley. And so, yes, there's these allegations, kind of bald allegations made at a prior proceeding, but no, the state would submit that does not arise to the level of proffer, of materiality proffer as contemplated by the Court of Appeals. And when specifically asked,
or instructed by the district court, go try these less severe methods to obtain her appearance. Look, we'll help you out. We'll get court services to step up and try to get you an address. Take these less severe methods prior to basically having her arrested. And if that doesn't work, bring it back. The defense never brought it back. And that's failure.
Was the judge that explicit? Did the judge actually say if that doesn't work, bring it back?
I think
the implication may have been there, but was that statement specifically made?
I think the judge was fairly clear in saying, we'll bring this issue back up once we get to that case. We're not, even starting your case yet where you would have to have her here. So, bring it back up after lunch, and then we'll address it at that time. I think that I can't quote to you the district court's exact words, but the district court was fairly clear in that, go try this. If it doesn't work, we'll go to the next step at that point.
Well, the court did, after they came back from this recess where they went and talked to the probation officer for Post, the court did specifically say that the officer had agreed to contact Post and to tell her to appear the following morning. And nobody objects. And then the next morning, state rests its case, Henley rests his case. That's it. Nobody says anything about this. So there does seem to be this piece missing from the record about what happened after the judge said, yeah, we're going to get a hold of her and tell her to appear. And there's no objection to that. And I guess I'd like for you to respond to defense counsel's argument here today that that's the state's obligation basically to now tell us what happened that morning. Did she appear? Was she available?
And I would disagree that it's the state's obligation. Under these particular facts, it's not the state's witness. The state was very clear that Ms. Post was never under subpoena for the state, that the state objected to her testimony being offered as inadmissible and irrelevant. And so, no, it would not be the state's burden to bring that back before the court. It's not the state's request that she be a witness allowed to testify. And it's the defense counsel's obligation, then, therefore, to create a record if you're going to then bring this issue up on appeal, and they have not created that record, which therefore limits the amount of inquiry that this court can do. I mean, if we're going to speculate as to what happened to Ms. Post, it's as equally likely that she did appear in response to the subpoena, and the defense counsel talked to her and decided not to call her as a witness. There's just nothing there that would allow this court really to provide any sort of meaningful discussion or inquiry into this issue because the record hasn't been provided, and it was the defendant's burden to provide that record. With that, I would like to turn to issue number 3, the multiplicity argument. State versus Schoonauer specifically recognizes that, yes, under most instances, a side-by-side comparison of different statutes' elements is what's going to be appropriate in determining whether or not they're the same crime. However, if there is some sort of legislative indication that it intends cumulative punishments, then really the comparative elements test is not appropriate.
And explain that to me in the context of separation of powers. I know there's some U.S. Supreme Court precedent from which we derive that particular rule, but why does, if the Constitution prohibits double punishment for the same conduct, why does the legislature get to determine what that double punishment is okay if they say so?
Well, it's always been the legislature's job to decide what the law is and what a crime should be and what the punishments for that crime to be, and this court's job to interpret that.
Within the framework of the Constitution, but there are constraints on what the legislature can punish, right? And one of those constraints is you can't twice put someone in jeopardy for life, liberty, whatever, for the same conduct. Isn't that what double jeopardy
yes, I would
protects
agree.
against?
Yes.
But we're basically saying, but it's okay if the legislature says it wants to do it. I just don't understand why the legislature gets to say if it is violating the Constitution or not. Isn't that the judiciary's duty?
It would be, but this case is not the first time that this court has said if there is the same course of conduct, but the legislature is intending to punish two separate aspects of that conduct.
I understand all that. I'm just asking, how does that fit within constitutional jurisprudence? it doesn't make any sense to me that we let the legislature decide whether it's violating the Constitution or not, because we have a separation of power. That's our job.
That is this court's job, but this court is also limited by what the issue raised in this particular case is. And the issue raised is possession of marijuana a lesser included of possession of marijuana without a tax stamp? To get there, we have to look at first, did the legislature intend to create two separate crimes from what could be considered the same course of conduct? Do they intend to punish two completely different intents and aspects of the same course of conduct and therefore create two separate crimes? Yes, it is this court's obligation to determine if that's okay. But again, this court has in the past found that if the legislature has two, explicitly different intents, even if there is the same course of conduct, it's not a violation of double jeopardy. It's not cited in my brief, but I know the State versus Cott decision, driving under the influence versus child endangerment, exact same sort of issues, same course of conduct, two explicitly different intentions of the legislature to punish separate types of conduct that just happened factually to be the same thing in the same case.
Well, and I appreciate that you're addressing this issue of some kind of intent that the legislature expressed, but you kind of summarily addressed it in your brief also, but as though there was such an intent, but I didn't see you point to anything about the statute itself or any other language that would allow us to make that finding, and I'm interested to hear what that is.
I would point to the fact that they are found in two completely different statutory codes. Possession of marijuana is found classified with all the other drug crimes. However, possession without a tax stamp is found under Code 79, which deals with taxation issues. It's lumped together with the same layout of the fact that we can issue drug tax stamps to people who are considered dealers, and how the stamps are to be issued and when they are to be issued and the amounts that we're supposed to charge people who come in to obtain these stamps. It's a totally different approach to the issue than simple possession and making the act of possession a crime. So you do have the fact that you have different codes, different chapters of the Kansas law, and I think that's a pretty explicit statement that these are not to be treated the same.
Well, as Mr. Hodgkinson said, I think he made a good point that, yes, it is different codes, but that could have been happenstance or legislative convenience, and there's no indication just simply because of the separate codes that had meaning, that they intended double punishment, essentially, for the same conduct.
I think you can further look at the fact that when you look at the Kansas sentencing grid, they're not sentenced in the same way. If the Kansas legislature had wanted tax stamps to be treated as a regular drug crime, they could have very easily said, when you're convicted of this crime, you're going to be sentenced on the separate drug sentencing grid. They didn't do that. They made it a regular non-drug grid offense. So I think that's a further indication that clearly these are two, the legislature intended to treat
those
these
are
as
lots
two.
of indications, but there's nothing, you have to agree there's nothing express about any of those. It's all implied.
There is nothing that I could find or did find that said in the tax code this is to be explicitly different. However, I think Canada's statutory construction is if the plain language and intent of the legislature is present, this court does not read into or out of.
How does it get any plainer than you can convict of the crime or a lesser included but not both? And a lesser included is one where all of the elements of the lesser are some of the elements of the greater. There's no exceptions to that. How do you get around that explicit, plain, and unambiguous language by implication of placement of the particular statutes in the statute book?
By the analysis in Schoonover, if the legislator's intent is plain and clear, you don't even get to the comparative analysis of the elements. If the legislature, it's sort of a progression analysis. If the legislature's intent is plain that these are to be treated separately, you don't even get to the comparative analysis, elements test because it would be inappropriate. If the court is going to find that the legislature's intent is not clear and that therefore we then move on to this comparative elements test, I think the Court of Appeals is right on. These two crimes apply to different people. As State versus Johnson, 283 Kansas 649 cites, if crimes apply to different sets of people, That's a unique element in each offense, therefore they can't be lesser included offenses. They also require different mens rea, different intents.
I'm sorry, what did you just say about the... Did you address Mr. Hodgkin's argument about the fact that what the Court of Appeals didn't point out was that a dealer is defined as a person? I mean, one is essentially the subset of the other, so it is included within that definition.
It's any person with a specific intent. And what the State versus Johnson opinion addressed was aggravated indecent liberties and aggravated indecent solicitation. And if you look at who those crimes are to apply to, under some factual circumstances, yes, those two different elements or two different groups of people could sometimes be the same person. It's one is the person of the child or the offender, and the other one simply says the person of another. Read, liberally, yes, there are times when those two things could be apply to the same group of people. However, the language is different, the intent is different, that those apply to two different people, and the Johnson decision said that you look at what the basic intended target is, not its specific or factual applications. That's where and how basically the Court of Appeals addressed that particular issue. And there's no reason for, I think, this court to address that issue any differently. But again, there's a different sort of, for lack of a better word, mens rea also involved. We have possession of marijuana, intent to basically possess to use an illegal substance, versus possessing intentionally without paying your tax. Those are basically, the state would have to prove different intentions of what is, yes, a possession. So if you have to prove a different level of intent on the part of the possessor, it's a different element in each offense and would be, therefore, not the same crime. Not all.
They instructed on possession or distribution of. That's how it was described. Is that right?
Yes, the possession conviction came about as a lesser included instruction of possession with intent to distribute.
Right, but I'm talking about the tax stamp violation was described as a dealer is who intends to possess or distribute. Is that how it was instructed? I think that's and does distribution make a difference in that? That's
no. The possession was given as a lesser included of possession with intent. The tax stamp was given as a separate instruction.
And the tax stamp includes possess or distribute language. Is that right?
The definition of a dealer, yes.
Thank you.
Your Honor, I see that I'm out of time.
Would you like 30 seconds to wrap up, Counsel?
I would very much. Thank you. The Court of Appeals basically applied this court's prior precedent on the issue of whether or not this should be considered a lesser included offense, found that they apply to different groups of people, therefore they are not the same elements. We would ask this court to make the same finding and also find that the defendant failed to carry through on their burden to prove either issue 1 or issue 2 and also affirm those findings.
Do we have any further questions of counsel before she sits down? Thank you, counsel.
Thank you.
Justice Rosen, just to answer your question, and it's a little bit startling sometimes to people when we find out that dealers, for tax purposes, actually you don't have to have any intent to deal.
Right, exactly.
And
So
the
it's based on
instruction does
quantity.
not. The instruction in this case, which is at page 118 of Volume 1, is that knowingly possessed 28 grams of marijuana. There's no issue about distribution because that's in fact not an element of no tax stamp. And so that's the...
Is that in the definition section, though?
I'm sorry?
Does that instruction define dealer?
It did not in this case.
It did not in this case define it. Okay.
Those ones.
And I just wanted to just to finish up on this multiplicity question that 213107 says, when the same conduct of the defendant may establish a commission of one crime under the laws of this state. I think the Controlled Substances Act is a law of this state, and I think the Tax Act is a law of this state. It's the laws of this state. The fact that they're in separate chapters, I don't see how that has any relevance under 213107. The last point I wanted to make on issue number 1, Your Honor, is the court has mentioned, it's exactly right, that defense counsel in this case, and this is volume 16, page 6 and 7, did say, it's not made up, that there's a long history of Ms. Post making police reports against Mr. Hensley. In one case, she writing a statement, gave to the police was false. So it's this idea that she's done this before, she's doing it again. and I guess I want to take this last minute to try to be more articulate in my response to you, having thought about it, Your Honor, is that I think our position is, once we've established a constitutional violation, the burden shifts to the state to show it's harmless beyond a reasonable doubt. And so to the extent that we've shown a violation, a constitutional violation of the compulsory process clause, by the failure to require mispost presence, that counsel's right. Maybe it's equally likely that she showed up on the second day, but if it's equally likely, that's not beyond a reasonable doubt. And so that is where I would come from, and I would, I guess, try to stick back to my guns, that the state does have responsibility once we show a constitutional violation to make a record that she showed up. They didn't do that in this case.
On the multiplicity double jeopardy issue, was there an objection at trial?
There was not, Your Honor.
So the only way you have preserved, the only way we can say that this issue is before us, it would be under the exceptions for constitutional error?
Your Honor, in our brief to the Court of Appeals, we acknowledged that this was not raised below, and we noted that, in fact, frequently, it's sort of the textbook issue, multiplicity can be raised for the first time on appeal because it's a purely legal issue and it's dispositive. We raised that in our brief. The Court of Appeals reached the merits of this issue, and the state did not petition for review from the fact that the Court of Appeals reached the merits of this issue. So I think as far as a preservation issue, there's no preservation issue before this court.
Of both the constitutional and the statutory components of the question.
Yeah.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.